6 a.m. to 10 a.m. from Nairobi to Mombasa, Kisumu, Nakuru, Eldoret, Nyeri, Malindi, and worldwide on www.spicefm.co.ke or SpiceFMKE on YouTube, Facebook, and Twitter. You can join the conversation anytime on our social media platforms, or also that also includes Instagram, which is SpiceFMKE. Now, we have a sister station called Vibes Radio. And Vibes Radio's slogan is "Nobody can stop reggae." But there are people who want to stop reggae. And reggae that we're talking about here is the BBI reggae. Raila Odinga has been saying, reggae has been on pause. Now we are on pause in reggae. We are going to press play and we will move with the BBI process, which is going to culminate into a referendum which will bring in some amendments to the constitution. Now, there are some activists, and these are 5 activists: Ika Langley, Wanjiru Gikonyo, James Gondi, Jerotich Seii, and David Ndii, who have gone to court, and they want the matter to be interpreted. And this is what their application is in the matter of threatened contravention and violation of Chapter 1, Chapter 2, Chapter 4, 9, 10, and in particular Articles 256 and 257 of the Constitution of Kenya, and on the application of the legal doctrine and theory of the basic structure of a constitution, the doctrine of constitutional entrenchment clauses, unamendable constitutional provisions, the doctrine and theory of constitutional amendments, the theory of unamendability of eternity clauses, essential features, supra-constitutional laws in a constitution, and the implied limitations to constitutional amendments in Kenya. Basically, what the 5 are saying is that in that doctrine, there are some structures of a constitution that define or make that constitution. There are some clauses of a constitution that actually are at the core of that constitution. If you amend that clause, you have changed that constitution. You now have a different constitution. And the one that the court to give opinion on this or to rule on this particular matter. For example, they are saying on issues of Chapter 1, which is on citizenship, if you amend anything on Chapter 1 on citizenship, which says we the people, the sovereignty of people have the sovereignty and they exercise that sovereign power through their elected leaders and with institutions. Okay? If you amend that, then you have changed the entire essence of that constitution. They are also looking at Chapter 2 and all the other chapters that I have read. And I'm going to just get straight into some of their arguments and read some of what they've presented before court. But I also will be discussing with them to understand what, and we're having this conversation earlier, CT. It's like saying, this is what defines CT Muga. Okay? As a person. You've got your unique features. You've got your thumbprint. If we chopped off your hand and fixed another hand and changed, therefore, your thumbprint, do we still have CT Muga?
The argument is even made more interesting when you consider the discussions around gender. What is it that determines the various genders?
Yeah. CT Muga is a man.
Yes, or the alternative, must it always be, or might it only be CT Muga could be a woman? Or better still, do we have genders that cannot be referred to as either or
the other?
Now, when you look at the argument around this, then this particular discussion that we are just about to embark on becomes even more interesting.
Yeah.
Because the same questions will arise. When you say this is the definition, what's the premise? And can it be the only one? Is there only one path to understanding this? Or could one use the very, very argument that you're using in converse and say, well, in so bringing this discussion to the fore, what you've actually done is proven the point that you are trying to disprove. Yes.
How?
Well, if you say that what you're talking about essentially is the principles that surround the structures of the Constitution, the moment you start saying that certain laws, if passed, certain ideas, if brought to their logical conclusion, will interfere with the structure, then what you've actually done is you brought in a discussion of whether what you're saying is the only truth that can be brought into the discussion. And probably this is why a determination on it is required. But it opens up a very broad discussion, very broad.
It does, really, doesn't it?
Yes, it does.
Because what, for example, they've taken to court, they're arguing about doctrines, and the doctrine and theory of the basic structure of a constitution, the doctrine of constitutional entrenchment clauses. Even in this constitution, there are some clauses that basically this constitution has said this can be amended by the people's representatives. This constitution can be amended either by an initiative starting from Parliament or from a popular initiative by the people. And we've seen like what Punguza Mizigo was. It was a popular initiative taking that route. And all this, there are some clauses that cannot just be amended by Parliament. They must go back to the people to participate in a referendum. But now they're taking it further and saying, even with that, there are some clauses that should basically be protected from any form.
All right.
If you want to change them, then you're changing the constitution. Let's go through the whole process like we did again and vote in a new constitution and promulgate a new constitution as a new supreme law of the country.
Now, do you see why it opens up the discussion? Because what you're essentially saying is that if you follow that very constitutional requirement of ensuring that it isn't something that is altered within our august houses, but it is actually taken to the people who are the owners of the constitution and the country, and then you have an argument which says, no, this one you don't need to take it to the people in this manner. You need to take it to the people in this manner so that this is what we do. As I said, you've opened up, not this one, as Ndii said this morning, barrel loads.
Barrel loads
Of
right?
issues. Yes, it isn't just a can of worms. Barrel load of worms.
I'm liking that conversation. And I just want to bring it back to when we said we define, this is Eric Latif. Okay? Eric Latif, what is it that
Constitutes.
constitutes Eric Latif?
Eric, yeah.
My blood group is known. I have the same blood group from birth to death. I have the same fingerprint from birth to death. I have certain features, all right? So yes, I've got a lazy eye. I can go and change this eye and put another one. I'll still be Eric Latif.
You have the same fingerprints.
Same fingerprint.
How did you manage that?
I have got my fingerprints. If we went and changed a finger, all right, and put in somebody else's finger onto this hand, and then we went to the government records, work a fingerprint up.
Right.
The records that we have for Eric Latif are this, and this is what now we are seeing. This person who's presenting himself. Is this Eric Latif?
So the makeup of you essentially has changed.
Has changed.
Yeah.
So should we be saying that this has changed? Is that what we're talking about, the basic structure? Anyway, let's talk to one of the people who've taken this matter before court and seeking interpretation of this. And this is Jerotich Seii, active citizen. Good morning, Chero.
Morning. How are you?
Good
Fine,
morning.
Very well,
you.
thank you. Good to
Good,
see you
good.
looking well, up and bubbly. The last time we were speaking with you, you could not really speak for so long without running out of breath.
How are you
Yeah, my
feeling
breath
now?
is back. My breath is back.
Fantastic.
I'm much better. Thank you for asking.
City asks, how are you feeling now?
How are you feeling now?
Are you asking me?
Yes.
Yes? Or would you like me to ask someone else?
No, I thought I'd answered. Actually,
No,
I am
you didn't
feeling.
answer. You said your breath is back. I'm asking a more comprehensive question.
This is Kenyan speak, but if someone asks you how are you feeling now, you
You
just
don't say
"I'm
fine."
okay."
No.
Give a little bit more of the story.
But the Kenyans like to say hello, fine. So
All right, we've gone through the fine stage.
But-
Okay,
but
now
I
how
am
are you?
better. Titi, thank you so much for asking. I'm much better. I have recovered. I am stronger. Some of the after effects, the recovery is still, ongoing, but more or less I'm at 99%. So I'm really back to normal and very grateful for that.
Excellent. Now you've responded to my question.
Good.
So, Chero, let's talk about the
Yes.
Constitution and what this Constitution is. Constitution of Kenya, 2010, promulgated in 2010. It's now 10 years old. It has its chapters. And then now, we've gotten to a point where even the president has said, look, it's 10 years. Let's look at what has worked, what's not worked. Let's tweak what's not working so that it works for us. A constitution is a living document.
Yes.
The BBI, has been looking at what is it that is ailing our country right now. It was not that this is a constitution movement, it was, what is it that is ailing our country? What do we need to do as people? What do we need to do that will be require some policy interventions, some interventions of acts of parliament, and maybe others interventions on the supreme law? This is a conversation that's still ongoing. We still haven't seen the final BBI report, but we saw from the initial report there were some things that, if they were to be taken, may have required some constitutional amendment. Then now we see the five of you bringing a very interesting conversation here, which is a doctrine of basic structure. What is this?
Well, I listened to your conversation, your overview and initial discussions, and I thought, good, you have grasped it very well. But one of the things I want to say is that, initially, as soon as we filed, everybody said, oh, this is against the BBI and so on and so forth, and so it as a counter attack. I mean, I think what I would like to underscore here is that the doctrine of basic structure of the Constitution is talking about more than what the final BBI report might attempt to push through in terms of future amendments, but rather looking at the whole in terms of the Constitution and saying, is it possible to immunize or inoculate the Constitution so that whenever there's elements of potential amendment, whether it's a correction or an elaboration, that we make sure that the core structure, the tenets of the Constitution, the non-negotiable elements of the Constitution are not infringed upon. And I think the whole discussion here is saying, if we are going to, and by the way, just to throw in, this did not start with BBI. Since between 2013 and 2020, there have been 13 unsuccessful attempts made by the Parliament to amend diverse provisions of the 2010 Constitution. So this is not something that came with BBI. There have been attempts for a very long time. And so we are exploring and seeking guidance and ruling on the doctrine of the basic structure of the Constitution. And we are saying that when you come in, and I liked your examples about the arm, CT's arm going. I was looking at my bookshelf actually the other day, and the books in my bookshelf, and I said, okay, I could rearrange the books. I could actually add to the books. I could decide to arrange them by size, or decide to even remove a book that is no longer useful as part of my collection of books. But the minute I take away the shelf that holds the books, then I have affected the structure of the bookshelf. Even if I try to put another shelf, it is no longer the original structure that we had agreed upon. And when Citi, you talk about opening up debate, I think this is really important, that debate should be opened up. And if people are sovereign, we the people, we are sovereign, we do have a right to look at our Constitution and see what aspects need to be changed. But what we are saying with this particular petition is saying, if we the people want to so fundamentally alter the Constitution, then perhaps we shouldn't be using articles that just allow us to amend and elaborate. Maybe we should go back to the drawing board. And the process to the promulgation of the 2010 Constitution was long and drawn out and deliberated upon, debated, and starts and stops, and finally we ended up with the promulgation after the Constitution of 2010 was put in place. So you can see that it shouldn't just be a simple case of an amendment here to alter that shelf in the bookshelf and say, yeah, we the people have said so. If we the people want to overhaul the Constitution, okay, let's go back to the drawing board, but not use these sneaky attempts to try and change aspects. And with this petition, as you said, Eric, we're looking at chapters 1, 2, 4, 9, 10, 11, 16. There are so many other chapters, but these are the chapters that give us cause for concern in terms of how they can be sneakily altered and adjusted, corrected, or elaborated upon, and affect the fundamental structure of the Constitution of Kenya.
Jero, what would you see as, you talk about, things that could be snuck in here and there for some kind of change. What would be some of the consequences that you see from these particular chapters that you've picked up on? What are some of the consequences that you see having effect on the people of Kenya who are supposedly holding on to sovereignty of this country?
You know, that's a good question, Ndii, because when I look at chapters 9 and 10, when you're looking at the executive and the judiciary, and also 11, when you're looking at devolved government, those are areas that really concern me. And when you look at the erosion of devolution, if you look at even how long it took to come up with a formula, county revenue formula. And some of the things, if you studied the Managed Equipment Scheme report that came from the Senate, last week it was released, you can see ways in which we have the executive violating consistently constitutional provisions that are put in place to protect and promote, in this case, Chapter 11, devolution. And this kind of slippery slope erosion of our respect and our fidelity to the Constitution of Kenya is what really worries us. Because if we now allow an amendment to be snuck in around Chapter 11, devolved government, and then around the judiciary, and you know the judiciary has also been under fire, or the executive, where you fundamentally alter the setup of the executive, we are really, really heading down a dangerous slippery slope, which will end us in some kind of morass, even though we say as the people, we voted in this plebiscite, or we agreed, or the parliament amended this or that or the other. We find ourselves in a place where the Constitution of Kenya no longer looks like the Constitution of Kenya.
But also there could be an argument that this same constitution and the drafters of the constitution foresaw the dangers of politicians trying to amend the constitution through the back door, just holding meetings and amending the constitution and loading it upon us. And that's why they included those clauses that say this specific chapters and clauses of the constitution can only be amended with the concurrence of a majority of the people of Kenya. And this is through a referendum. So already the constitution is well protected against any sort of manipulation that goes against popular opinion. If a majority of the people of Kenya think that it's about time that we amended a certain clause, and all together a majority of them go ahead and vote in a referendum, what's wrong with that?
You know, you make a very good point, Eric, and I would agree with you, except, and now let us just jump into BBI, because in any case, we are being seen as an anti-BBI constitutional petition. Let's look at the BBI. Yes, it is true that people are sovereign and that we would, the elusive final version of the BBI report might go down a path that would be popular and require a plebiscite, a referendum. When that happens in a genuine manner, where there's complete engagement of the people, not what we have seen with BBI when they did their road trips around the country. Yes, they may have visited every one of the 47 counties, but how did they engage? And when I read the first draft of the report that was released last year, it was evident to me, and I said it, and I've said it in other fora, that it wasn't that Wanjiko or that Mora or that Fatma or that Wakesho or that, Chepkoech, who was sitting around saying, we want a prime minister, or we want IBC to be restructured this way and that way. So in the case of BBI, my fundamental concern, having read the first draft or the first report in detail, is that it is creating a situation and setting Kenyans up to believe that it is them, the Kenyans, we the people, who actually want this. When in actual fact, I call it the Trojan horse. So you present something and say popularly, here we are, and we are going to run a referendum, and yes, this is what the Kenyans want. But is this what Kenya wants? Was I consulted? Were you consulted? And this is what we are trying to safeguard against, that we have political processes that try and mold the constitutional provisions to suit their political agenda that has nothing ultimately to do with the people of Kenya. So yes, you might say they have used the correct pathways, and yes, we the people, and there's a popular initiative, and so you can't say to politicians who are running this show. But this is still a case of the tail wagging the dog, or the Trojan horse, as I call it.
The argument is sound for argument's sake, but consider, if you look at even the constitutional processes that we had in this country, there are many parts of it that followed a similar path. Opinion gathering, perspective gathering, the whole 9 yards. And people will go by what they remember as having been considered, not necessarily included, considered in the discussion. Now, if we're talking about the BBI, this is what the BBI seem to have attempted to do, and they seem to have convinced the populace that they did go around the country and they did seek the opinions of the people who live in our various counties. Now, when you then bring in a specific argument such as the one that you have brought, then you then have to explain again to the same people, then what do you consider to be public participation, if not this?
Actually, I see Dr. Ndii has joined, and maybe this is something that he could jump in with.
Yes, indeed, he
So
has.
please go on, because let me catch on. I had a bit of a mishap, but apologies for that. I'll explain.
All right. Welcome to the show, Dr. David Ndii, economist, columnist, and author. We are, of course, talking about the bid to stop the reggae of the BBI, but also just trying to understand what is it that we mean by structure of a constitution, and what is it that exactly we mean by, ring fencing some parts of the constitution so that they are not subject to any form of mischief or abuse. But just as Dr. Ndii catches up, Chero, when you talk about popular initiative, and that's what City is saying, if you look at a popular initiative which is started, 1 million people at least signed signatures. This is verified by IEBC. This is taken through the 47 county assemblies. It is debated. It is passed by the people's representatives in at least half of those county assemblies. It goes to parliament. It then goes to the people in a referendum. Surely, the people have been involved in that entire process of trying to amend that bit of the constitution.
Yes, but what if the people's involvement, and like I've already said, so I will not belabor the point, I'm a bit skeptical about this involvement business, but let me suspend my disbelief and say, okay, the people were involved. What if the decision is still to cut off C.T. Muga's arm, as we had earlier used, or to remove that shelf in the bookshelf?
Well,
there should be a space where even we the people understand that there are certain aspects or elements of the Constitution that we cannot popularly decide to amend or correct or elaborate without affecting the fundamental nature and structure of the Constitution. And when that is the case, if the people really want to cut off C.T. Muga's arm, then we need to go back to a different process, an entirely different process, where we come back and say, okay, this C.T. Muga, why is it that we want to cut his arm off? And if we're going to cut his arm off and use a prosthesis or a bionic arm, then we need to go about it in a different way, not this popular initiative, which is linked to, Articles 255, 257, where you can come in. This was designed for minor amendments. So we could clip C.T. Muga's fingernail, but not cut off his arm, whether it is popular or parliamentary. That's what I'm trying to say.
Let's bring you in now, Dr. David Ndii, and thank you very much for joining us this morning. So the whole discussion here is around protecting the supremacy of the Constitution and looking at the people and wondering whether the people should have a say in how they can amend their constitution. I also see another side of the argument as well, which is saying if you touch on certain aspects of this constitution, you might as well just be saying, let's overhaul the constitution, bring in a new one, but don't say that you're amending. If you touch this, then you have changed. If I cut off Dr. David Ndii's head and put on Eric Latif's head, that is not Dr. David Ndii.
Thank you very much. Sorry, I again, sorry for had a bit of a physical mishap. That's another story. Let me start by giving an example. I don't know whether you follow African politics. A couple of years, about a decade ago, an Islamic party ran for elections in Algeria on the platform of abolishing the secular state and establishing an Islamic state. And they actually won the election. At that point, the Algerian military intervened and said, okay, Algeria, being Algeria as a secular state is sacrosanct. You cannot use the Algerian democracy to abolish democracy, even though the people, you've managed to sort of mobilize, whip up the emotions of the people at that particular point in time, which were mostly, sort of dissatisfied people with various types of governance issues. Now, what followed was some kind of civil war, civil strife, which went on for quite a while. Now, if Algeria had this sort of jurisprudence, law on what the basic structure of its constitution is, that party would not probably have run on that platform because it would have been futile. We know that India's current government, BJP, would probably want to establish India as a sort of Hindu nationalist state. But fortunately, India, which is one of the pioneers of this kind of jurisprudence, the Indian courts have declared secularism, even though it is not mentioned in the Indian constitution. They have declared secularism as one of the basic structures of the Indian constitution, even if it doesn't say anywhere that India is a secular state. So I think we need to distinguish. What I'm saying is that how are the people acting when they endeavor to change some things in the constitution? Are they acting as sober people, or are they acting as a mob? Yeah. So that is one of the things. So the fact that people are doing something, it doesn't mean that they support the people are doing something. Doesn't mean they're doing the right thing. People have done horrible things as mobs, about genocide and stuff like that. The other thing is that we have a history of repealing a constitution by amendment. The Independence Constitution, there was no point at which they said, now we are abrogating this Independence Constitution and establishing an imperial presidency and restoring colonial laws, these are repressive laws. It was done by stealth. I think a total of 35 amendments or thereabouts from 1964 to about the mid-70s. Actually, right up to the enactment of Section 2A in 1981. That is what it took. It was repealed, a new dictatorial constitution established by stealth. So what we're saying is that political processes, people can destroy their own constitution and even destroy their own society. It is not an issue. And the process and the reason why we did this constitution was, in fact, that's the mischief that we were trying to cure. And it took us 20 plus years to do so. And I don't know whether you sort of would recall that, but immediately this constitution was ready. There was a workshop held at KIA by the government, the people who are in government then, and they proposed over 200 amendments to the constitution. I mean, it was there were so many amendments that it became quite clear that what they were trying to do is repeal the constitution by amendment. So that is why we looking at what is going on in the country. We're looking at the number of constitutional amendments that have already been proposed since this constitution was enacted, including some which are live in parliament at the moment. We feel that Kenya probably needs this kind of jurisprudence.
So basically, you're going to court to seek the court's intervention in protecting the people from themselves.
it is not protecting the people from themselves, but protecting what the people. You see, our constitution, I think, and if you go to our constitution is very clear. It speaks the language of it is called progressive. It speaks the language of being transformational, being aspirational. So that kind of constitution means that it is something which society sets as something which is going to transform society over time, to deal with certain problems that the society knows that it has. Now, the fact that the constitution is like that, it is because we know ourselves. If you look again where this comes from South Africa, for instance, with its history of apartheid, when they also passed what they said is a transformative constitution, said, look, we are not going to change overnight. We are going to change. We passed the constitution which set a very high bar, and then we reform ourselves to reach that bar.
Yeah.
But human nature is that our instinct is to slip back. Okay? So it is true. We know what, so if you draw that parallel, we have set a constitution which sets a very high bar, and we are supposed to push ourselves towards that direction.
Right.
Now, you know that one of the things we did is we set a very high bar of Chapter 6, and immediately we slipped back. Because of certain political exigencies.
Yep.
So it is not protecting the people from themselves, but it is pushing the people forward and putting a ratchet so that we don't backslide.
Right.
Of preventing ourselves from backsliding.
From backsliding. We're speaking with the economist, columnist, and author Dr. David Ndii and active citizen Jerotich Seii. Post your comments and your questions on our social media handles, Spice FM KE, Twitter and Facebook. Broadcasting from Nairobi, Mombasa, Kisumu, Nakuru, Eldoret, Nyeri, Malindi. Worldwide on www.spicefm.co.ke and on our social media handles, Spice FM KE on YouTube, Facebook and Twitter. This hour, we are looking at a constitution conversation. Because even as the president said, it's about time we started looking at this constitution. So let's discuss the Katiba, okay? There are 5 Kenyans who have gone to court seeking interpretation and determination of the court. And this is Ikala Ngelei, Wajiro Gekonyo, James Gondi, Jerotich Seii, and Dr. David Ndii. And they've gone to court seeking interpretation, and especially on doctrines and principles of... There are some things that are the cost and basic structure of the constitution. And if we start tinkering with those in any way, then we are basically repealing this constitution. Maybe we should, protect them. And that's what we are discussing in this hour. C.T. Muga, Ndii, Eric Latif, and Dr. Ndii and Seii. C.T., you've got a question?
Yes. This name written clearly, Ndii, how is it pronounced again?
Ask him.
Daktari, how is your name pronounced? I do not wish to call you by a name which isn't yours.
That will do. The name is pronounced Ndii.
Ndii. All right. Now I've got it. Now, there is on page 17 of the Standard a tweet that is attributed to you. It says, our petition is not about the BBI and makes no mention of the BBI. It seeks to establish a judicial principle that will protect the Constitution from mutilation now and in the future. Lovely statement. I like it. What is this judicial principle?
The one that the President has just talked about, that the Constitution has a basic structure that should not be interfered with by amendments. As I said, if you really want to repeal the Constitution, then you need a process of repeal. You do not use amendment as a Trojan horse for repealing the Constitution and putting in place another one. For instance, if that jurisprudence existed at independence, I think it would have prevented the amendment which created an office of Imperial President for Jomo Kenyatta.
And by extension, it would have guaranteed that the Majimbo system would also not have been extinguished.
Exactly.
Okay.
So now tell us then why you pick on these specific clauses and chapters of the Constitution. For example, Chapter 1 on sovereignty of the people and supremacy of the Constitution. Why would you consider this a basic structure?
Well, you cannot convert Kenya into a monarchy. That's what we are. If you can, but not under this constitution.
Mm-hmm.
Yeah. So the people are sovereign. I think that is very fundamental. They are also devolution is also follows very quickly. I think in Article 2 or 3 that there are two levels of government in Kenya.
Mm-hmm.
I think national and county government.
Yeah.
So I think if one wants to introduce a different level, I think that would be debated there. It doesn't mean, let me say, once you put these things, the nature of this interpretation that we're seeking, what it does not mean that amendments cannot be proposed, but it gives people who think, it gives people a basis for debating whether those amendments are valid. So what we have now is we have a constitution, but we have not the one in which anything goes. You can amend. You can amend everything. And as you know, the constitution, as we argue in the petition, it exists as a whole. So it is possible for somebody to look for a vulnerability where they are looking for a weakness. You know, you look at where can I poke, sort of, which is a weak point, and you say you're only amending one or two clauses, but really what you're doing is looking for a weakness that will bring the whole structure down. Yeah. So what this does is, if amendments are proposed, it is possible for people to go to court subsequent after this, if our case goes through, and say, look, the amendments that are opposed actually offend the basic structure of the Constitution, or people are using constitutional provisions to do unconstitutional amendments, stuff like that, so that the court has something to work with.
And so what would the person be going to court to seek the court's intervention on? If it's still allowed that you can propose amendments to these particular chapters, but they are basic
there's
structure.
Nothing to stop you. There's nothing to stop you from, at this moment, for introducing a state religion. Okay? And if you introduce a state religion, and the majority of people voted for it in a popular process, as has been attempted to do other things, the courts would have no option but to accept that we introduce a state religion.
At the risk of repetition, if I can just, so what essentially you're saying here is that it's not that you can't change the Constitution, but if you want to change, if there are any changes that you want to bring about for whatever reason, then you must do this by, being public about it, number one. And number two, you must go to the relevant authorities and with the knowledge of the people to make sure that you bring about those changes with everybody's visibility on it.
No. We are saying there are some things that you cannot take out, and there are some things you cannot put in.
Okay.
For instance, you cannot put in state religion. Okay? As of now, the process provided for by the Constitution leaves the gap that you can introduce a state religion. Okay? So you're saying, since there are people who might be tempted to introduce a state religion, and Kenya is overwhelmingly Christian and oppressive, there is a gap through which oppressive constitutional amendments can come introduced. Can come through. We saw, for instance, we have seen this thing called 1 man, 1 shilling. It completely offends the public finance principles of the Constitution. Yeah, because we have said in the Constitution that one of the grievances that we were addressing was the marginalization and exclusion. And we therefore put in provisions, what you call directive principles, that public money should be used to bring about an equitable society. And we have seen people openly saying we are going to reverse this. So right now, there's nothing to stop them from doing so.
I want to bring Go ahead. Sorry.
I think if this petition of ours goes through and you try and do something like that, it means when somebody goes to court and say this sort of thing offends a very fundamental thing about the Constitution, which is actually a Bill of Rights, and then you are stopped at the gates.
But there's nothing at all that, even in your petition, that stops the people of Kenya from repealing this Constitution.
No,
not at all.
None
but
at all.
You cannot use it. But you cannot use the same Constitution to repeal it. The Constitution does not provide for provisions for repeal.
It doesn't.
So
it doesn't foresee its death.
Pardon me?
It doesn't foresee its death.
No, it doesn't foresee its death.
Okay. So, yes, Jero, you were to say something.
No, when I think about it and I say in simple terms for Kenya, and as an active citizen who tries and break into bite-size or understandable sizes what's going on, for those who will be out there told that this is an anti-BBI petition, we need to find I was thinking, how do we simply explain it to Kenya? The Constitution, Articles 255 to 257, would allow for minor amendments. These are minor amendments that are supposed to help us better achieve certain articles or aspects of the Constitution that could have done with a bit of tweaking or a bit of correction, or that would allow us to engage in a larger change, like a bit of an elaboration. But these are minor. They exist within the framework of this Constitution as is. And what we are trying to say is we do not want a situation where people overstep the minor nature of their power to amend and force us into spaces that completely and ultimately undermine the Constitution of Kenya. So we are saying this is to safeguard the Constitution of Kenya. And anybody out there who is thinking of using the pathway of amendment to tamper with our sovereignty as the people of Kenya, even by using the same people of Kenya to go out and vote in a popular initiative, we are saying, no, you cannot do that.
But if I look at the Constitution itself, and because there's an entire chapter on how you can amend this Constitution, 255 already says you can amend the Constitution, but it ring fences some clauses and chapters and says these ones can only be amended by, via referendum. That is, by everybody participating in that process. And if a majority approve, then it's fine. And these are some of the ones that you're actually putting forth in the petition. Supremacy of the Constitution, the territory of Kenya, sovereignty of the people, values, principles of governance according to Article 10.2, and then the Bill of Rights, term of the President, independence of the judiciary and commissions, independent offices, functions of Parliament, object, principles and structures of devolved government, and the provisions of this particular chapter itself. If we want to amend 255, we must go through a referendum. So just using that argument, don't you say that the drafters of this particular constitution already saw what you are raising, and those are legitimate fears, that we could have a way in which a process by which this constitution is completely mutilated and looks something completely different within another 10 years' time, by saying that if you want anything like that, use the people. The supremacy of the people says that they are the ones who shall determine what changes in these particular clauses. Now, by listening to your petition and your argument, you're saying that let's go even further and say that even if the people went and unanimously voted, 99.99% in a referendum voted to change Chapter 1, some aspects of Chapter 1, that would still be wrong, because Chapter 1 is the basic structure and it should not be amended unless you're bringing a whole new constitution and call it Constitution of Kenya 2020.
You got it right. And Dr. Ndii has already elaborated a bit earlier on about the bad habit that we have of trying to amend or bring in fundamental changes via amendments. And you're absolutely right. At the end of the day, if any of these amendments move beyond the minor, the ameliorating, to a space where we are fundamentally altering what it means to be we the people, then it doesn't matter whether the people vote in a referendum or not, we still say no. And we as the people, because we are not sitting outside of the people, we are part of we the people of the Republic of Kenya, we say no. And that's why we're seeking guidance. And we're saying what jurisprudentially, how do we move forward with this? And I like what Dr. Ndii also says, with this petition, depending on the outcome, it can always be used going forward. And people can quote it as case law to say, this is why we cannot allow the following amendment to happen. So if, for example, the famous, infamous BBI says we want a prime minister, we want to alter the judiciary thus, or we want to alter the executive in this way or that way, or we want to tamper with devolution, are those minor amendments or major? And if they are major, is the amendment route the route to take? Or do we seek a completely different way of reviewing, repealing this current constitution, going back to the drawing board? So we are not allowing stealthy and sneaky ways of bringing in fundamental changes and then hiding it behind the fact that people came out in 99.9% said yes.
But
let me step in there
yes.
and elaborate. I think we are complicating something which is not. If we stop talking law and technicalities and talk politics, we have this constitution. We passed this constitution of struggle saying we want to go this way as a country. We want to become democratic, equitable, blah blah blah, all sorts of things. Now, there are people who don't agree with that. Don't forget, said we are going forward, and there are people who say we should go backwards. Okay?
Yep.
And we're saying that the people of Kenya agreed to go forward. Okay? But the fact they agreed to go forward, it was not without a struggle. Okay?
Yep.
Now, we also, the court, the constitution gave the court, we gave the courts the power to improve the constitution. Okay? Or by things like this. Because whatever declaration of the Supreme Court, of the courts, of the constitutional courts, become part of the Constitution. So you're saying, look, we want to make sure that people will not whip up popular emotions to take the country backwards. It is quite possible. You know, constitutions in a democracy, the purpose of constitutions in democracy is to restrain power. So what we are doing here is to improve the constitution by preventing people using constitution to abuse power. Yeah?
Mm-hmm.
Because there are people who definitely want to take us backwards. Yeah? Mm-hmm. And that struggle is always there in society. In the US, even today, there are people who are against equality of black and white people.
Dr. Ndii, when you talk about this, when you talk about the abuse of power, and just going to what Jerotich said earlier about now making it understandable for people to see what's really going on here, could you look at what are the dangers then of not taking this into consideration? And I'm talking about Kenyans at large. What are the dangers of not putting in those safeguards to make sure that, for example, that there is no abuse of power? Because most times you can't see something until you see what threat it is to you as a people. What are the dangers then of not putting these safeguards in place from where you see it?
That's what we're saying. What is it that in Kenya, in the Constitution, what political fight, what did we settle with the Constitution? We have settled structure. Okay?
Yep.
So we're saying structure values, the various things, the fact that we want a constitutional aspiration, not a minimalist one. Yeah, there are very many things that we have settled.
Right.
Okay?
Yep.
Now, we did not put in a process of saying there's an amendment, there's a proposed amendment offend those things. Okay? Like, for instance, the German constitution, which was done after World War II, given where they were coming from, Nazism, they put in democracy as an eternity clause. You cannot amend that clause in the German constitution. It's called an eternity clause. Okay? So given where society is coming from, we're saying 10 years after the constitution, we passed the constitution, we are learning, we have observed that there have been many, many attempts to take us backward. Because there are people who benefited from the system we had before. And they are still resisting in sort of the progressive changes that the Constitution
Provides.
envisaged and the people of Kenya envisaged. That's why you are hearing people saying, what we need is the Constitution being implemented.
Yep.
Okay. So what we're saying is that we have seen the need for a ratchet, so that when we make progress, elected people don't come and then push us backward, so that we'll be forever taking one step forward, two steps back, and we are backsliding. So that when we make progress, we ratchet it. When we make progress, we ratchet it. Yeah?
Yep.
So what we are safeguarding against is dishonesty. That there are people who grudgingly accepted that this is where society ought to go on a values basis.
We are speaking with Dr. David Ndii, economist, columnist, and author, and active citizen. Jerotich Seii, these two and three others have gone to court seeking the court's intervention and interpretation on safeguarding some clauses and aspects of the Constitution. And what they are explaining is, let's look at it from the political process and from the political side of things. There are some things that, well, if we change, then we're basically changing the entire structure of the Constitution. We want to continue with this conversation and ask now for your feedback, your questions to Dr. Ndii and Ms. Seii. If you've got any questions, 0719-012-600 or our social media platform, of course, Spice FM KE on YouTube, Facebook, and Twitter. This is a Situation Room. It's Kenya's biggest conversation. Spice FM KE, Instagram, Twitter, Facebook, YouTube. You can pose your questions or even your comments right there, and we will be sharing them with our guests this morning, Jerotich Seii and Dr. David Ndii. Chero, as we went to the break, Dr. Ndii was explaining, I mean, this is about, let's look at what this constitution is a result of. It's a result of a lot of work that went into trying to bring ourselves to a level where Kenyans express their aspirations and they put them in the supreme law of the Republic. The supreme law also says that the sovereignty of Kenyans are sovereign, and the sovereignty will be exercised by the people through their elected representatives or directly. The Constitution also provides for these amendments, and where the people, there are some clauses which says the people must unanimously agree, or at least by a majority agree that this is the way to go. Now, when I listened to the debate this morning, I am agreeing to some extent with the debate, but something at the back of my mind is telling me it's sort of like if your petition went through and it was actually agreed on by the judiciary, we'll be creating an imperial constitution. A constitution that we created, but then it tells us you cannot touch me going forward because I don't trust that you'll have the ability, wherewithal, or even the goodwill when you are trying to amend me. Yet, we had the wherewithal and goodwill when we were creating it. It's like saying that this constitution then tells you that if you want to question your own sovereignty, you cannot question it because you told me 10 years ago that you're sovereign. If you want to question your structure of government, 10 years ago you said this, but once you said it, you cannot change your mind. Is that not going against the same principle of people exercising their sovereignty? Chero.
I think there are definitely pathways to achieve the changes that we, the people, would want to achieve. And what we're trying to say is the sneaky utilization of the amendment route is what we do not want, because it has been overused, misused, and abused, and moved away from the aspect or the element of minor corrections to ameliorate, and into the realm of deeper, more nefarious fundamental shifts. So it is not that we, the people, cannot amend our constitution or cannot look for pathways to even repeal the whole thing, but saying, let us use the correct pathway, and this is not it.
What are these pathways, if I may ask? I know you've mentioned it. Just mention it again. I'm a little slow this morning, so when you first mentioned it, it sort of like passed me by.
No, but Dr. Ndii, and I think he can jump in here as well, had said that, look, if you want to repeal, then use the repeal process. Don't repeal via amendment.
Yeah, let me jump in. I think there's also, you have to sort of put this in always in context about law. Very often, law is to cure certain mischiefs that are there in society.
Yep.
So, when we say that we passed the constitution for eternity, there is a reason for that. Yeah. Now, let me draw again an example. When the U.S. passed the constitution with that famous place called "All Men Are Created Equal," they had slavery. Okay.
Yep.
And even today, that society is still trying to achieve that aspiration.
Right.
But what they could not say is what existed at the time, because it was based on moral values, moral concept. What existed at the time that one race was superior to the other. South Africa did, quite not too long ago, in the 1940s, have a constitution which recognized that races are unequal. Okay? So, if we abstract too much from the reality of society, we say that, we are creating an imperial constitution. Yes, constitutions are, when societies conceive them as eternal. The democratic constitutions, societies conceive them as eternal. And what we're saying is that we believe that they represent the social contract, as I said, of the people of Kenya. But there are certain political struggles within society that will continue to exist. And what we cannot do is use the process created by the Constitution. We cannot weaponize democracy, which is that is what it is. You cannot weaponize democracy to undermine the Constitution. In a nutshell, that's what you're saying. What you're saying, or democratize the sort of processes such as participation and all sorts of things, and you say we have ticked all these boxes, and therefore we can introduce state religion into the Constitution. Or we can abolish Islam, practice of Islam in Kenya.
But why not, David Ndii, if the people decide that this is the new route? You see, 10 years ago, when we were going to a referendum in August, and having read the constitution, the draft constitution that we had given to ourselves, we hoped that it would serve us well. There were things that we put in that constitution, we the people, and we believed that this is the best way for us to go. 10 years or 15 years or 25 years down the road, we are faced with new realities, and those new realities of our time tell us, you know what, that decision that we made 25 years ago has probably not served us well. It has led us to deeper problems than we thought we were getting out of. So let's change that. And that's the whole principle of amending a constitution.
No, it is not. There are principles, there are values, there are known, there's moral content. There's moral content in the Constitution. Okay? We are creatures of reason. Okay?
Yeah.
So, we are saying that we should have a framework of reasoning when certain changes in the constitutions are contemplated, so that we can debate and decide whether those changes are in the best interest of society. And the institution that we have given the responsibility for moral reasoning is the judiciary. Okay? So we cannot use, we are saying we should preclude the possibility of using a purely mechanistic process and saying we have ticked all the boxes and put in the constitution something which is morally repugnant.
Dr. Ndii, let me ask this. The Ndii clause you mentioned, is it the same thing as that is often referred to as an entrenchment clause or something? Are they the same thing?
Yes.
Now,
Yes.
if you look at the countries where this has been applied, as you said correctly with reference to the United States and Germany, there was a very fundamental reason.
The U.S. doesn't. I just mentioned Germany. It has one entrenchment clause. One is under the clause.
Yes. I was mentioning the U.S. as an example that you gave, that the background to the initial statement, all men are created equal, because they were unequal to begin with. But in Germany, you do have an entrenchment clause, and the other countries in the world, in Africa, we have Algeria, we have Egypt. But the point, what I'm trying to ask here is this. The entrenchment laws make it absolutely difficult. In some cases, they make it impossible for you to change that law. But now, coming back to Kenya, how exactly do you see the changes that seem to be favored and furthered by a politician? How do you see it taking us back to an imperial presidency or a monarchy, as you called it?
Again, as someone mentioned the tweet which I said, look, we are not anticipating what what changes people may bring, but we know we are capable of political mischief. We have already seen in our affidavit, we have a long list of proposed amendments since the constitution was enacted. None of them has gone through. Some of them are still live in parliament. Quite a few of them have a lot of mischief in it. So you're saying we are not perfect, and we know that. Okay, we have passed an aspirational constitution. People fall short of their aspirations all the time, and they slip back. So what he's saying is, let us improve our constitutionalism. Let us improve our constitutionalism by having a process that will arbitrate whether a proposed amendment, whether popular or not, however popular, is consistent with the values, with the promise we made ourselves. Is this a case of us going forward, or is it a case of us going backward? Are we backsliding, or are we going forward? All we are saying is that let us have, asking the judiciary, allow us to have a criteria by which we will evaluate proposed constitutional amendments, so that we protect those things that we believe are dear and the spirit of why we enacted this new constitution against our worst nature as people.
So essentially the background is we have already seen mischief, not just imputed, but actually practiced by people who are supposed to be our lawmakers and the protectors of the Constitution. So not to sleep on our own guards, you want to ensure that there are mechanisms that guarantee that this path that some people seem to have determined to follow doesn't go the way they have thought it. Is that what I understand you to be saying?
It's a very good to put things bluntly. Take, for instance, a parliamentary process.
Yep.
We know that it is possible to intimidate or even bribe the entire legislature.
That's true.
Okay?
Yep.
And if the legislature is corrupted and intimidated, it can pass morally repugnant amendments to the Constitution. We want to be able to go that, and then you have a problem, because the parliament is a lawmaking body, and the judiciary, we say Parliament having made the law, there's nothing we can do. You can say it's unconstitutional, but it's a constitutional amendment, so it is now constitutional for us to chop people's heads off. Okay, So you're saying, no, the higher standard. The higher standard is that in passing this constitution in 2010, this is the kind of society Kenyans wanted. And what you people are attempting to do offends that in a very, very fundamental way. So we cannot, it is unconstitutional by virtue of the direction that will be given if our petition goes through. And that is how it is used. That is how the basic structure jurisprudence is used in India, where it's used a lot, because there are always people who are trying to do the same thing. But when you think about the Indian society, there's the same issues: religion, caste, all manner of things that majorities can use to oppress minorities.
Yeah, that is a very.
And that we are saying we have certain elements of the same things in societies where we see this, and we are therefore asking that we introduce the same remedies that those societies have used to protect constitutionalism in their countries.
You know, City has actually called it before, and it calls it lived experience. In our lived experience, in our short history as a Republic of Kenya, we have seen one constitution get mutilated in a span of what? Was it just 20 years? Between 64 and 81? It completely looked different from what came back from Lancaster. We have that. We already have elements in our political class who have expressly demonstrated their unwillingness to abide by this constitution.
Yes.
So, of course, giving them an opportunity to tinker with it, they will run with it. And we have also seen how politicians use the populace to champion causes that are in their own personal interest and not in the interest of the public. And this is what we're even discussing the 7 o'clock hour. Public interest versus politicians' own selfish interests. So it's a very interesting conversation. We want to open up the phone lines now. Any comments or questions? Just hold on, Chero. So we have a caller on the line, and this is the Honorable Shakil Shabir. Good morning, Mheshimiwa.
Good morning. I was in the Constitution CKRC when we set up, and we worked through a number of years on from 1997 on the issue of the Constitution. I mean, 1997 was not the Constitution review, but the earlier movements. Yes, IPPG and others. Now, one of the major problems that we first met and we first decided on is what are we going to do about the Constitution that will not be mutilated, and where the values of Kenya and the values of the Republic will be maintained at all times, so that we do not go back to the 1963-64 debacle. So as David Day is saying, there are certain pillars of the Constitution that cannot be touched, even by way of a referendum. What we will need to do is to go either repeal the whole Constitution and go back and say that, listen, these are the pillars that we feel are wrong at this moment in time in this 2022 century. But we cannot do it piecemeal. That is my first intervention. My second one, and people have been talking about two tiers of government. We had 2 tiers of government. It was mutilated in Naivasha. The 2 tiers of government were the provincial government and the national government. And then under the provincial government, there were going to be district executive mayors or whatever. You see, the only problem is that we've allowed our constitution to be mutilated in Kilifi, in Naivasha, and the same people who are now going for BBI are the same people who mutilated the constitution in Naivasha.
In recent history, in the last 15 years.
Yes. Then, I mean, the 2000 and after the constitution was proposed, the draft, the Kilifi draft, then it went to Naivasha, and Naivasha was very clear on how the government was going to, what was the structure of government. It was mutilated. And they came up with 47 governors and et cetera, et cetera. In Parliament, there were about 10 of us who were fighting this. Martha Karua was one, I was another, and we were walking out every time there was an amendment. But obviously we were outnumbered. So what we're trying to say is this: the BBI is a tweaking. Maybe we can allow tweaking. but we cannot allow basic fundamental changes in the constitution.
Thank you very much.
That's my take.
Thank you very much. That's the Honorable Shakil Shabir, the MP for Kisumu East constituency. 0719-012-600. Join this conversation. Let's hear what your thoughts are. We know that people have gone to court and they're saying, well, and this is we have 2 of the 5 that have gone to court asking the court's intervention. Sharo, before we pick Shakil Shabir's call, you wanted to come in with a comment.
Yes, I wanted to just further illustrate and I do agree 100% with Mheshimiwa who called in, and the idea that there's the essential and core features of the Constitution that are these basic building blocks and should not be tampered with. And we have what we have. It was promulgated. If we want to change it, then we know what we need to do. But I wanted to bring in an example that I had raised at the very beginning of the show, which is a medical equipment leasing scheme. And this whole process where to date, when you talk about the tens of billions of shillings that have disappeared in criminal activity, one of the things that struck me most when I read that report is that every one of the 47 counties of Kenya have paid 619 million shillings each since in the past 5 years. Now, these millions that they have paid to lease this equipment would have been paid out of the coffers of the county government. But there was a circumvention of that, and none of these counties ever saw this money. This money was paid directly through Ministry of Health to the contractors. Now, this flies in the face of public procurement, of finance management, and also devolved government, Article 187, and the functions of devolved governments and what their autonomy is. Now, what if somebody decided that this is a very pesky thing, this aspect of say, Article 187, and want to alter it and change it so that going forward, even though we have a devolved system of government, you can centralize certain functions.
Yep.
Now, wouldn't that be interfering with the essential and core feature of the Constitution of Kenya 2010 with regard or with respect to devolution? And this is what we are, and so this is an example which is actually very separate from the BBI discussion. What if somebody went in and amended and made it possible to circumvent devolution? And do we still have devolution? Is that a minor tweak, a minor amendment, or are you fundamentally affecting what it means to say we have a devolved government? And these are some of the things we want to safeguard against, these cheeky or whimsical or nefarious or even criminal attempts to alter the Constitution willy-nilly. And worse still, when you popularize it in a populist manner and make the people think that they are the ones who want these changes.
Thank you. Let's go back to the phone lines. Barry calling in from Nairobi. Good morning, Barry.
Good morning, Eric. How are you?
Fine, thank you.
I think the first thing first, I don't know how I can join that petition. It makes so much sense for me, let me tell you. Because one, the purpose of a constitution is not to appease to the whims and desires of the majority, but to protect the minority from tyranny of the same majority. That's what causes justice in any society. Now, if the constitution does not, like you see, if we now to leave the constitution like in the context of this country, the constitution does not define a system of mobilization. So are we saying that we can sit here and allow someone to mobilize the society even in an illegal way, maybe through religion, through class, or through tribe, and propose what seems to be a popular amendment to the detriment of the very minority who are still members of this society? I mean, that can't be allowed. From my standing, I believe that constitutions are meant to protect the minority, not the majority. So any measure that is meant to prevent the constitution from the mischief, especially of the political class and the larger and the powerful members of the society, that is so welcome for me. Thank you, guys.
Asante sana. 0719-012-600. Join the conversation. Dr. Ndii, how can Barry support your petition?
I think that we'll look at that. We'll look at that. I think people can always. It is possible for people to enjoin themselves in petitions. I am not a lawyer, so we will seek guidance from lawyers how that can happen. Because I think it is also important that if other citizens, like he feel strongly that this is something they want to be part of, I think probably there should be an opening. But we'll find out.
It's interesting that he has mentioned that, because just as Barry has said, how can I join? Then it makes me realize that there are lots of Kenyans, a lot of people who may not actually realize, who may not actually understand exactly what is going on. And until something like this comes to the light is when they might actually now put their thinking caps on and say, all right, this could be happening as we sit back and watch. In terms of information spreading for something that seems to be quite difficult to understand for a lot of people, or may not even have the time to sit down and go through it, processes like this, apart from this petition, wouldn't it be, how important rather, would you see that being in terms of getting Kenyans rallying around a knowledge base and understanding of what is really going on with the laws of the country?
Let me say, from my experience, as Shabi was saying, I've been in this for a long. We went through constitution making for a very, very long time. This is one of the longest, and there has been so much civic education in Kenya. So comparatively, Kenyans tend to be very alive to these issues, which is why you are seeing all this sort of interest. And in fact, this petition, the spirit of it, I think, from our perspective, is to bring that about, to bring that development. We saw this jurisprudence and said, look, we have the same problems as these societies which have adopted this.
Right.
Yeah. We use the language of tyranny of numbers. Now, constitutionalism is in fact, as the gentleman said before, constitutionalism is a safeguard against tyranny of numbers. And the way that we have drafted, even though we have provisions of clauses which are protected, are ring-fenced and can only be passed by referendum, it is not insulated against tyranny of numbers. As that gentleman has said, he was very clear, politicians or other forces can mobilize religion, they can mobilize ethnicity, and then use the tyranny of numbers to undermine our constitutionalism. All we are saying is that by adopting this jurisprudence, this principle, it doesn't have to be written in the Constitution. It says part of our constitutional amendment process will include evaluating whether it offends the basic structure of the Constitution. That is the only innovation that we want to introduce, so that you can go ahead, but you know that your amendment will be audited. It will be audited to ensure that it is not mischief, that it is actually doing what the Constitution already says, that any amendments or even any rulings are to actually improve the Constitution in the direction that we have said we want to go, which is very clearly set out in Chapter 1.
Going back to the phone lines, 0719-012-600. Amani in Nairobi, good morning.
Good morning, Eric. Good morning, Ndii. Good morning, Seii. How are you guys?
We're very well, thank you.
Great conversation as usual. I just have two comments or contributions. And that is, the first one is the first segment of the politician. Yeah, and then I'll come to this current segment.
Okay.
Yeah, for the politician, it was about academic qualifications. And I felt that is not the only absolute condition. When you look at the American Senate or House of Representatives, you have people of all ranges in terms of educational backgrounds, from truck drivers to policemen to lawyers, etc. So I think what's important for a politician is to have the necessary researchers and consultants, not necessarily professional consultants. They can consult widely within the community, especially the community leaders, in terms of understanding what is required of them in terms of their work and what they need to deliver to the people. So I think that's important for any politician, regardless of your academic qualifications.
Good point.
Yeah, and then now on this particular issue of the interrogation of the Constitution and the changes, I think this is very important, what this petition is doing, because the Constitution is such an important document. It cannot be taken lightly. It cannot be left solely to the politicians. And therefore, it is necessary for the civic society and the general wananchi to interrogate it in such a way that the issues are brought out as to what the pros and cons are of making any changes, so that people are making informed decisions about what needs to be done. It may be that we don't need this, or yes, this is okay, we can do this part, but not the other part, because it compromises the entire Constitution if we change, let's say, Article A, B, C, or X, Y, Z. So I think this is very important, and this discussion you're having is absolutely critical. So please continue with it, because we need it. And good luck to everybody.
Thank you very much, Amani. 0719-012-600. You want to join the conversation? Also, Spice FM KE on YouTube, Facebook, and Twitter. Let's go to Nyeri. Simon is calling in. Good morning, Simon.
Good morning, Latif.
How are you doing? Welcome to the Situation Room today.
Well, thank you very much. And I'm privileged, quite privileged to come back to you again from yesterday. My MP was there some time ago, some hours ago, and he talked about something, the difference between academic qualifications and lack of it, for that matter. And to a certain degree, I agree with him, because in order for one to hone the charismatic leadership that is required largely in politics, one has to at least go through some technical bit of education, so that, including the diplomatic part of it. However, there is the charismatic element that is actually hereditary. And such people, when they get into leadership with commitment, they become very good leaders.
Yeah.
And I think for the purpose of catering for that, that is why members of parliament have been given big offices with research departments, so that they can be able to bring in all sorts of the resources, the requisite resources that they require to facilitate their jobs.
I hate to interrupt you, Simon. What do you have to say about the current conversation, which is the petition, on safeguarding aspects of the Constitution, such that if you want to amend them, then just like Dr. David Ndii and Ms. Jerotich Seii are saying, you've got to ensure that it's taken through a proper audit, so that we safeguard the Constitution against mischief.
Well, there is a certain element to it that is noble. Because if we allow a section of the people to mutilate the Constitution every time they require to do so, on some of it on personal means, we shall end up having no Constitution at all. However, there is a danger to going towards that direction, because once the waters are tested and they are found to be soft, we again invite a barrage of such amendments through one arm of government, that is the judiciary. I am quite aware of the jurisprudence that are common all over the world in terms of making the Constitution amenable. But we cannot actually make the Constitution through the judiciary.
Okay. Let's get the feedback from our guests, Dr. Ndii and Ms. Seii. What do you say to that? He's saying, look, the other danger of that is now by saying that some of these amendments have got to go to the judiciary, and if the judiciary concurs, then you can go ahead. You're now introducing the judiciary as an arm of amending the Constitution.
That is not quite correct. Judiciary has no power of initiating anything. Judiciary waits for things to be taken to them. Like we have taken. So you can see judiciary as the place minority will go if the majority tries and use the tyranny of numbers against them. As someone said, so the judiciary, the only way that judiciary makes law is when cases are brought to them and they rule in a particular manner. And the reason why that becomes law is, again, even constitutional law, is again because people don't have perfect foresight. When we were writing the Constitution, we could not foresee everything that will be relevant in the future. And then you cannot then be, again, amending the Constitution all the time to take care of circumstances. And that is why, that is the merit of using our power of reason in a tempered manner. But certainly the judiciary cannot initiate constitutional amendments, but cases can be taken to it where using the time-tested and all sorts of other accepted processes and rules, they can have they become part of the body of your constitutionalism. I think there is no perfect way. There is no perfect way because you cannot be updating the Constitution every 5 years. There is no alternative other than the fact that there will be unanticipated things. For instance, we've just had a pandemic, which will probably shape the way we look at certain things going forward. You could not have anticipated that before. So that might actually, there might be something coming out of that which will change our laws, perhaps even something with constitutional implications.
Well, thank you very much for the conversation and your insights this morning. And as we conclude the conversation, Dr. Ndii, what would you tell Kenyans to do in order to remain vigilant in protecting the Constitution and the democracy? What is it that people ought to do?
We must resist being mobilized on the basis of sort of political emotions on the here and now, particularly on the basis of ethnicity, to undermine things that we have sort of stated that we hold dear. We must resist following individuals blindly. I am quite sort of surprised at seeing that people are prepared to reduce the constitutional or at least to instrumentalize the constitution for power politics. Only a decade after we had to enact a new constitution, partly as a result of the 2007, even though we had done it before. So I think what really we would urge Kenyans to do is to be sober, and to really engage the things that we are. For instance, why we brought this petition. When BBI does come, and we hope that this may have gone through, that we look at it soberly. If there are constitutional amendments proposed, let us look at them soberly.
Thank you very much. Jerotich, Seii, what would you say?
You know, I would end by encouraging as many Kenyans as possible to be active citizens, because when we are active citizens, then we are not passive recipients of information that tells us what to do, when to do, and how to do it. And the other thing I would like to say is that the wording of our petition, when we talk about seeking the court's intervention to immunize certain chapters of the Constitution, what is immunization? It means that the disease is around. It's not eradicated. It's not like smallpox that was eradicated. You're looking at diseases that are prevalent, but we're looking to immunize, for example, children, so that they don't catch that disease. In the same way, we are seeking to immunize these chapters, because the disease, and in this case, the disease of willy-nilly nefarious attempts to alter the Constitution, we know that it will always be there. There will always be things, whether it's BBI, whether it's other things, there will be factors and politics at play trying to influence the Constitution. And we are seeking that immunization so that we can protect some core chapters that, if altered, would change the fundamental nature of the Constitution of Kenya 2010.
Dr. David Ndii, economist, columnist, and author, and active citizen, Jerotich Seii, thank you very much for joining us this morning, and we wish you all the best as you pursue this petition.
You. Thank you for having us.
Thank you.
And
Thank
do
you.
enjoy.
Yep.
We enjoying. Asante sana.